Welcome back to Spaulding Injury Law Podcast. I'm Abby, and today I'm here with Ted Spaulding from Spaulding Injury Law. Good to have you back, Ted, and thank you for being here today.
Yes, thanks for having me.
So driving in Atlanta is its whole own thing. We see crash patterns here that most of the country does not. And what we're going to get into today is how that type of crash you're in shapes the injuries you are likely to suffer, and how those injuries in turn shape what your case is actually worth under Georgia law, whether it is a rear end on the connector, a T-bone at a downtown intersection, or rollover on Georgia 400. The path from crash to compensation looks different, and knowing the difference changes the outcome. So Atlanta has some of the heaviest mixed traffic in the Southeast. Commuters, commercial trucks, rideshare drivers, and tourists all sharing the same roads. What are the most common type of car accidents you see here in Atlanta, and how does the crash type shape the injuries a victim is likely to suffer?
Yeah, so there's three most common types of wrecks. The first, which is the most common, is obviously your rear end collision. Then you've got head-on collisions and T-bone collisions. So those are your top three. The ones that you don't see as often would be like your rollover type wrecks, your massive pileups of 4, 5, 6 vehicles. But those are your big three: is your rear end, your T-bone, and your head-on collision.
Yeah, and anyone who commutes through Atlanta knows how quickly traffic on the connector can go from 60 to a dead stop. When someone gets rear-ended on the downtown connector or I-285, how does that affect their injury claim?
So it affects most potentially the value of it, because you're talking a rear end collision, which obviously can happen anywhere. But if you're talking the connector, 285, even 85, 75 in different areas, you're on a major highway. So speeds are typically larger than in your surface roads. So anytime you have higher speed, naturally you may have larger injuries as a result. And of course, the whole point of what I call this exercise, which is having a personal injury claim and maybe a lawsuit, is what are your injuries, and therefore what's your treatment and your pain and suffering. The more of all of that, as I tell people, it's worse for you personally. We don't want that to be the case, but because it's worse for you personally, it means you have a higher valuation case, because it's all tied to what are those injuries and how long are you suffering trying to recover from them.
And then these are the crashes where the injury profile and the case value jump dramatically. How do T-bone intersection crashes and head-on collisions produce Atlanta's most serious injury claims?
Yeah, that's a really good question, because those do tend to be the ones that cause bigger injuries. Why? Because now you're talking, especially in your T-bone situation, you're talking about force that's coming from the side. And as you can imagine, that's going to really jostle your body inside of the vehicle. That is the mechanism of injury. Oftentimes you hear it initially called whiplash of some sort, right? It just means your body is violently moving forward and back, sideways, and that sort of thing. So when you've got a T-bone, a head-on collision as well, it's the reverse of a rear end in the sense that they tend to be your larger injury than a rear end collision, but it's still going to cause you to go back and forth inside the vehicle. A good example, this is a T-bone collision at an intersection that we had. We actually tried this case last year. It was a pizza delivery driver on a side road at a four-way intersection. And my guy is going straight through. He's coming the opposite direction straight through, but he's wanting to turn left. And so he didn't have an arrow. My guy has the green and is coming up over the intersection. He turns left in front of him. But instead of it being a T-bone, traditionally, it was more of a head-on T-bone collision. So hit him at an angle, but it was sort of head-on. Now, what that caused were two major injuries for him. One was a shoulder injury because he's holding the wheel like this and it jerks him this way and it rips his shoulder. So he has a shoulder rotator cuff injury and needed surgery on the shoulder. It also caused more typical injury, which is a herniated disc in his cervical spine. Needed a surgery there as well. Now, this case, we Our last offer was 2 days before trial, and it was only $550,000. We ended up trying the case because of his injuries. The jury came back at $3.28 million because he had a fusion surgery on his neck alone, and that is a permanent injury. You've got hardware in your neck for the rest of your life. So really, it can become significant injuries in something that you would otherwise think, yeah, it's a head-on collision, but I'm otherwise okay. But look what this gentleman had to go through for years and for the rest of his life.
Yeah, that's a really good example of that type of crash and the compensation that can come from it. Each of these crash types creates its own set of complications that a standard two-car fender bender doesn't have. How do rollovers, multi-vehicle pileups on I-280, and hit and runs each change how a compensation claim actually works?
Yeah, so the major ones that change things, rollovers not necessarily going to change anything. It's just a more severe wreck. We were talking earlier about the different types of wrecks and which ones can lead to the more severe ones. Rollovers, definitely. You're more likely going to have things like broken bones, crush injuries, concussions, or other major brain injuries. That's the real difference with rollover. But your other two examples have other unique problem sets and things that change value. One of the biggest ones being hit and runs. What we see with hit and runs, less on your major roads like 285 and the others, but more on your surface roads, definitely in downtown Atlanta for some odd reason. Hit and runs are problematic because it is very rare that you ever find the driver. As strange as that sounds, I've had where we got video evidence, but it doesn't show the license plate, just the make of the, it is so hard to actually find. So what happens? Now you're dealing with what's called an uninsured motorist situation because the person cannot be found that hit you, therefore you can't find insurance. Now you're fully relying only on your insurance coverage if you have it. And we talk about this in other videos and things. It's called coverage. And the problem with that is if you don't have it, which you don't have to have in Georgia, you're out of luck. Can't find the other driver, can't pursue them, and you don't have any insurance protecting yourself. So hit and runs are really scary for that reason when you can't find the driver. The other one that you were talking about, multi-pileups, separate issue, but all surrounding insurance for the most part. When you have multiple vehicles involved, you're typically going to still have probably just one party that's at fault. Now, you could have multiple. So there's one way it could change things, but the bigger scenario is it's still one party that's involved, typically the last vehicle causing everyone else to hit into each other. If you have multiple parties injured, which are more likely to when you have multiple vehicles, you could have multiple drivers, multiple passengers, you have multiple people going after one pool of money, which is the insurance coverage of this at-fault party. So much like your hit and run situation, you know who the driver is, they have insurance, but they're not going to have enough. And you've got multiple parties, what we call is a chase of insurance. Who's going to go get it first? And when does it run out? For example, you could have a scenario where you got 8 people injured. If the at-fault party only has minimum Georgia coverage, that is $25,000 per person, but only up to $50,000. So it only covers 2 people at the $25,000 level, or $50,000 split up amongst 8 people. But here's the catch, and this is where, not to get too much into the minutia, but people need to know, the insurance company has every legal right to just pay out 2 people, the full 25 to each of them, and then we're done. We have paid out our limits. So sorry to the other 6 folks. We've already exhausted our limits, and you cannot argue, hey, that was inappropriate. You should have given money to us and that sort of thing. That's why it becomes a chase to insurance oftentimes in these pileups. Again, like the hit and run, what often comes into play for our clients is we hope you have coverage again, because it's not just when it's uninsured, it's when it's underinsured. The at-fault party did not have enough insurance to cover the full value of your claim. It would still kick in. But again, what folks have to know is in Georgia, you are not required to have coverage. And there are so many people, we have so many cases where their claim was worth 20, 30 times the minimum coverage and they had no coverage. So you're stuck with $25,000. In a pileup case, you could be stuck with zero because, again, they exhaust it to everyone else. And all you can do is turn to your insurance. And if you don't have it there to protect you and your family, you're going to be out of luck, even in a multi pileup where you know who the driver is that was at fault.
Yeah. Okay. So listeners, if you want to hear more about coverage, go back and check out episode 2 where we get more into it there. Those are, great explanations there. We have covered the crash types that happen on Atlanta roads, from freeway rear ends to intersection T-bones, rollovers on Georgia 400. Now let's talk about the injuries themselves and how the type of injury drives what your case is actually worth. So whiplash is the most common injury after a car accident, but it is also the most commonly disputed. Why do insurance companies push back so hard against a soft tissue and whiplash claims, and what can someone do about it?
Yeah, so that's a great question and several things to unpack there. Number one, you are correct. It is the most common type of injury, which is whiplash. And so number one, they do it because it is the most common type of case that they have. So you got to figure you're not the only one that has a claim at this point for soft tissue injuries in a whiplash type case. You're not the only one in the state of Georgia, much less the entire country, that these big insurance companies are dealing with. So they've got tens of thousands of these at any given time. So number one, it's just because it's the biggest one. So you can imagine they'll dig in more, because if they can save money on each of these, even though it's a smaller amount of money. And so people often wonder, God, it's just a soft tissue injury. Why are they fighting so hard? We're talking a couple $1,000s maybe difference, or 10 grand or something. Why are they fighting so hard? Because again, it's not just about your case. They're looking at the global landscape. And if they have so many of these, and they save $2,000 here, $2,000 there, it adds up. So number one, it's just the volume. Number two, it's because they can. And what I mean by that is often in these cases, it's not about fault. It is about what's called causation, which means relating your injuries to the wreck itself. When we're talking soft tissue type injuries, that's where they can dig in, and all they got to do is create doubt. Oh, they have a soft tissue whiplash neck injury. Well, that wasn't caused by this wreck. It was caused by something earlier, because there's no definitive proof, right? If you have a broken bone right after a wreck, there's no fight over causation. Yeah, you broke your arm in the wreck. Where else did it come from, right? But when it's these internal injuries that can easily come from a ton of other places, it just gives them that natural, let's just throw some doubt out there and say they probably were already living with neck pain and those sorts of things. So it's a nasty combination of those two things. It's financially worthwhile for them because there's so many of these cases. And two, the injury just naturally lends to, we can throw a bunch of mud up on the wall and see what sticks. It was something previous. It's something else. It was a sports injury. You might have had neck pain years before, but it was better. We're still going to point to that. It's just easy for them to make those types of arguments.
And then traumatic brain injuries are the injuries that can quietly change someone's life. And the ones that most often go unrecognized at the scene. What are the signs of a traumatic brain injury after a car accident, and how does a TBI diagnosis change the value of a claim?
Yeah, so the common symptoms are ones first that are easy to detect. That would be things like vision issues. You're having memory issues. It's typically short-term memory, right? Like we have clients that say, I went to go get my keys and I was supposed to go down to Kroger. I go to that Kroger twice a week, for 10 years, and I couldn't remember how to get there. It's those types of things. Light sensitivity is another one. Headaches is another common one. Less common would be like agitation, things like that. Maybe you're, someone who was very laid back, and then all of a sudden your family members are talking about you're getting angry at a drop of a hat type thing. Any of those kinds of things could be your signs. Now, one thing to keep in mind with headaches is, again, getting back to most of these have some whiplash involved with it. Headaches don't necessarily mean a concussion. Headaches can oftentimes just come from having a neck injury itself, or even shoulder that's radiating up. So trying to differentiate a headache that's associated with a concussion type injury, which is a traumatic brain injury, or is it coming from the neck, might take some time to understand. Now, your second question, TBI cases, which is traumatic brain injury, and again, a simple concussion is a traumatic brain injury. Those have very significant value. The reason is because oftentimes there is no real definitive treatment, especially for your lower grade type concussion injuries. It is simply having to let the brain heal itself. And so what you end up typically having in these cases is less in medical bills, but a longer drug out pain and suffering case, because it could take 6 months to a year to even 2 years for your brain to fully heal. So you're talking about all of these very annoying and difficult injuries to deal with: memory loss, headaches, light sensitivity, all of this kind of stuff, potentially for 6 years or 6 months, a year, year and a half, 2 years. That is a lot of pain and suffering to have to go through. Now, you could have a massive TBI, which is beyond just a concussion. You've got bleeding on the brain and those sorts of things. Now we're getting into massive brain injury that could be permanent for the rest of your life. Good example, I had a case, a young man in Savannah area. He was on a motorcycle. It was involving a police officer of all things. And he struck his head. He had his correct helmet on and everything, but he had a hematoma on the brain, which is bleeding on the brain, caused long-term brain injury, TBI. That permanent injury that he's going to have to deal with to a certain extent for the rest of his life. That case right before trial settled for just under $800,000 because it was years of having to deal with that injury and potentially for the rest of his life, and what it means if, God forbid, he got another concussion down the road or anything like that. It just makes everything even more difficult for him. So these TBI cases, unfortunately, they can be very big cases because, again, we're dealing with an injury that is sometimes horrific.
Yeah, and that's something that people don't really think about, is those different complications on the case. So then this next injury is something that can change someone's life permanently. The ones where the number gets very large very quickly. What kinds of spinal cord injuries happen in Atlanta car accidents, and how does paralysis change the compensation picture?
Yeah, so much like the TBI situation, in a spinal cord injury, you can have a range of different spinal cord injuries, okay? Your most common spinal cord injury is a bulging or herniated disc. And for those that aren't familiar, the disc is the jelly-like substance that's in between each of your vertebrae. And the point of it is to be a shock absorber. So as we are upright, walking around, sitting around, it's there to keep the two vertebrae bones from hitting each other. So it acts as a shock absorber. Now, obviously, when you're in a wreck, that can bulge or herniate, and it means it pops out. If it's a spinal cord injury, it's popping out into the spinal cord, and going down through your spinal cord are a bunch of nerves. And then the nerves shoot out to different areas, your arms, down your legs, those sorts of things. So if you have a herniated disc, it could affect your limbs, and it's a really big injury. These are pretty darn common injuries to get in car wrecks. Probably the most common injury that we deal with on your higher end scale of injuries. Now we're talking, it's still a soft tissue injury technically, but it is a big, big injury. Think of the example I gave earlier. You might have to have a surgery. These are permanent surgeries with hardware put in to fix that disc because it's causing so much pain and limitation. So very, very significant. Now, your most significant is what you mentioned, which is paralysis. That is massive. Now we're talking permanent, lifelong, massive injury. You're not going to recover from it. You're probably paralyzed for life. Hopefully you're not, if it's just for a certain amount of time and by the grace of God, you come out of that paralysis. Still a very large case for obvious reasons, but most paralysis cases are permanent. And we're talking, you're in a wheelchair for the rest of your life. You can't move an upper extremity for the rest of your life, dealing with all that pain and suffering. I have seen even recent here, probably in the past 6 months to a year, verdicts in Fulton County alone in paralysis, permanent paralysis cases in the $25 to $30 million range. And what often shocks people is in my opinion, it's the largest valued case, even over wrongful death. Because the difference is you're talking value of the life of the person in a wrongful death case, and you're living through massive pain and suffering and loss of enjoyment of life for 10, 20, 30, 40, 50 years, depending on your age. And so the verdicts tend to be massive for obvious and correct reasons in these paralysis type cases.
And as someone who has had a herniated disc, I feel like I want to say thank you on behalf of everyone who has had one of those injuries where you take it so seriously. And I think that it just shows how you just really empathize with your client. So that's amazing. These are the ones that can feel a little bit more straightforward to most people. But the case value varies wildly depending on exactly what broke and what surgery is required. So how do broken bones and internal injuries factor into the value of an Atlanta injury case, and why do some fractures pay more than others?
Okay, yeah. Fracture cases and internal injury cases are, in my opinion, easier to pursue. Why? Because remember what we were talking about earlier, your typical injury in these cases are internal ones, sure, but they're these spinal cord injuries. It came from anywhere. I have literally deposed an orthopedic surgeon who says you can literally get up out of bed and herniate a disc. Now, if you can just by getting out of bed herniate a disc, imagine what they're going to be arguing. Oh, this didn't come from the wreck. You could have gotten it anywhere, right? But then flip it to these broken bone or real internal injury type cases, like you've got an organ or something like that internally. You don't have that same argument, right? It's simple. Causation, meaning did it come from the wreck, is simplified. Okay. So that is always a good thing because you have less argument over where did the fracture to your wrist come from. I didn't have it before the wreck, and it obviously happened in the wreck. So that helps valuation because there's less gamesmanship on where did the injury come from? Oh, it could have come from somewhere else. It's very clear. Now, within each of those, you're right. As lawyers say, and it's frustrating for clients, and I get it, every case is different, right? You always hear that. You hear it on commercials, right? Oh, just because we got this settlement doesn't mean we're going to get it for you. It is true because one fracture could have a different value than the next one. And the reason, again, remember what this is all about. What are your injuries? What treatment did you need? And what kind of pain and suffering? So you can have a simple fracture where you didn't need a surgery. They just had to cast it and you had 6 weeks for it to recover and boom, you're great. That's awesome. It means you have a lower value case than the next person that has a different scenario, but that's good for you personally, right? Because it only took 6 weeks. Think of the other person, same fracture, but they had to have a surgery, put plates and screws in. That's permanent, just like we were talking about with cervical spine type injuries. That's a permanent placement of things in. That has a bigger value because you're going to have that in there for the rest of your life. It may require another surgery down the road. Those have to be replaced after 10 years or so, right? So now we're going to have future medical costs. Then you get into your severe ones. I've had clients in the past where, okay, yes, you need a surgery. It's not just cast and it's better, but then the surgery fails for some reason. It's causing nerve issues now. Got to go back in, redo that surgery. Now you're going to have higher medical costs and those sorts of things. So that's why every case differs. The type of fracture differs, right? Another example would be certainly a difference between you have your non-dominant hand broken and a foot or a leg. You might be on crutches. You might be on a wheelchair for 6 weeks with a leg because you can't walk around. That, again, that's more pain and suffering on the scale, more loss of enjoyment of life than the next person. So it all depends on what exactly is your story. What did you exactly go through? And that's why I often tell people you don't want to overuse prior examples. Like I gave you with that verdict that we got, 3.28 million. Well, the next person, I don't want to just cite to that and say, hey, that's what your case should be, sir, who was in a similar wreck with a cervical spine, because your course may be different. Yours may be worth 5 million because he only had one surgery. You might have had to had two. So it's the same kind of scenario with your broken bone. And again, it goes with internal injuries. You know, if you've got internal bleeding, those types of internal injuries, that's right away type stuff, right? It happened. It's blunt force trauma, those sorts of things. There's nowhere else to point to where that came from. It's clearly the wreck. So it makes it much easier on the causation front. And then the valuation, again, will take care of itself, because what did you need? Did they have to remove the organ? You know, did they have to do some other kind of surgery? Or was it one of those like a TBI type thing where, look, there's nothing we can do. It's going to resolve itself. There's no surgery. Just give it time. And those all have different valuations.
And then with the next type of injury, these are the injuries that insurers have the hardest time valuing, and juries often respond to most strongly. How do PTSD, emotional distress, burn injuries, and permanent disfigurement affect what someone can recover in a Georgia case?
Yeah, so the first set, and I'll start with PTSD because it is a common thing that I see. And what I tell people is, you know, way back in the day, I had this big burly, he was a professional bodybuilder, right? Like man's man kind of guy. And he was in a nasty wreck, and he had PTSD from it, and severe PTSD. And so I tell folks, even when you're not, you know, Mr. Tough Guy, you know, PTSD is legit in these bigger car wreck cases. I see it time and time again. Insurance companies don't like it, because they think, you know, they're trained to think everyone's making things up. Everyone's, you know, exaggerating. And of course, no one can see it. You know, PTSD, it's just what you're self-reporting. Oh yeah, of course you're scared, you know, blah, blah, blah. But it's legit. And it has value. Again, much like a brain injury, there's not much treatment for it. Yes, there is some counseling. I've had clients that have gone through it and it's really helped, you know, with coping mechanisms and those sorts of things. But it's a nasty kind of like mid-range pain and suffering type thing that can just last for a real long time. And it's just not fun. You know, it's not fun to, you know, avoid the connector or 285 because that's where your wreck occurred. And anytime you're on that road, it reminds you of it. Or, you know, stop and go traffic scares you or whatever. That's not fun to have to go through and like have to divert to other roads and that sort of thing. And that is the same with emotional distress. Every case is going to have emotional distress. It's different for everybody. Some's mild, some's a lot more severe. You know, depression can kick in because of the injuries and the change of your life. Anxiety, similar to PTSD. Those are all absolutely legit. They all kind of go into that pain and suffering category because that's part of your pain and suffering. Pain and suffering is not just the physical pain. It can be the emotional pain too that your physical injuries are causing, or the wreck itself in a PTSD situation. Now, burn injuries, those are very, very severe, big cases as well, kind of like right below your paralysis, wrongful death, sometimes herniated disc ones, and the larger burn injuries. Why? Because again, you're talking about one, not only a severe situation causing emotional distress, PTSD, but potentially lifelong injuries. Burn injuries, you can, you know, do surgeries and those sorts of things to fix, but oftentimes you're going to have something, scarring for the rest of your life, sensitivity. A lot of burn injuries, you can't go out in the sun like you could before. You have to apply a lot of sunscreen and those sorts of things. I had a case in Dawsonville, Georgia, several years ago. It was a propane case of all things, where my client worked at a propane tank farm, if you will, and a truck came in and did not have had 50 propane tanks stacked up in this truck, but they didn't secure it correctly. And so one of them fell off as they pulled up and blew up. And he's right there, and it blew up in his face, seared his, you know, 3rd-degree burns over, I think, 40% of his body. Just horrible case. Guy was in his 20s. Not only was that painful as hell, and for a long, long time, he had to have multiple surgeries. I think he had 20 surgeries just to kind of get it under control. And then he's got permanent skin damage for the rest of his life. That's a massive, massive pain and suffering type case. That one, I think we resolved it right under $1 million, I believe. I think that was all the insurance coverage there was. But just a massive type case in these burn injury situations. Permanent disfigurement kind of runs along the lines of burn injuries. You can have it for other things as well. We get a lot of permanent disfigurement in dog bite cases. And again, you got your entire range. You can have small permanent disfigurement, still disfigurement, scars from surgeries, okay? Scars from bites, those sorts of things, up to your burn injury, permanent disfigurement. Heck, like you were talking about herniated discs. I hate to hear that you have one. Client has a surgery for it. You're going to have a scar for the surgery. And if that's on your neck, it's going to be massively visible. If it's in your back, okay, shirts and things like that can cover it up. But permanent disfigurement is a big item of damage because, again, it is for the rest of your life. If you have it in areas that are super visible, I've had several on the face. That's going to have a higher valuation than one that's, on your chest or your back or whatever, because you can't hide it. It's there, and it psychologically affects you every single minute of every day, especially the larger it is. You can try to have surgeries and things like that. Now we're talking even bigger medical bills and those sorts of things. But permanent disfigurement is a massive item of damage that needs to be pursued aggressively for just compensation.
And then these two issues cover a huge percentage of cases that get contested and one of the most misunderstood doctrines in injury law. How do delayed onset injuries and pre-existing conditions interact in a Georgia case? And what is the Eggshell plaintiff rule?
So this is probably the biggest thing to talk about because, like you said, it is the biggest thing that gets discussed and fought over in these cases. Again, most of the times in car wrecks, it's not about who's at fault. Yes, it can come up in certain cases, but most it's not. It's about causation. And this is where that fight comes in. Insurance companies and defense lawyers naturally and understandably love pre-existing conditions because remember, their job is to say, if they can, legitimately, this injury or a portion of it or some of it came from somewhere else. It did not come from the wreck. Easiest one's pre-existing. If they can point to something, other car wrecks in your past where you had treatment for this area of the body, sports injuries or work-related injuries to that area of the body, they're going to call it a pre-existing injury case. Folks, it didn't come from here because look, they had treatment years ago for the back as well, and it was from another car wreck. They had it all along. Okay. And what they're basically saying without saying it, because they're unfortunately not dumb enough to say this in front of a jury, the plaintiff's lying. Their injuries didn't come from this wreck. It came from something pre-existing. And they're just trying to make money off of this case by saying, oh, now, all this back issue is from this wreck. They love pre-existing. Delayed onset, what people need to know is almost every case, again, unless it's the ones we talked about earlier, burn injury, broken bones, blunt force, internal trauma, most of these are delayed onset cases because most of them are your spinal type injuries, neck and back, biggest injuries in the world on these things. And those things, they're often not immediate. Hours, days, weeks. I've had cases where it took the full effect of a back injury to kick in for a month, 2 months. And then they find out they have a herniated disc. The delay is natural and it happens. But what does the other side do? They use that against you because, again, they're just trying to throw doubt. So the case I told you about earlier, the trial that we had, $3.28 million, he did not go to the emergency room right away. He just wanted to go home, which was natural. That's what most people want to do. I just want to go home. I'm going to sleep it off. His neck and shoulder were hurting a little bit, but he didn't think much of it, thought he was going to be fine. He waited 1 week to go to the emergency room. And then even after that, he then waited another month to really get into treatment. So those were our two biggest issues because they're saying, folks, they want all this money. He's got this surgery. He's got another surgery he needs on his shoulder. And he's saying it's all came from this wreck, but he didn't treat right away. He didn't treat for a week. what happened during that week? It could have come from somewhere else. Clearly it wasn't bad enough. He didn't go to the emergency room right away. And then even worse, folks, he gets checked out. They didn't find the herniated disc then. And then he waits another month. Well, our story was that's what normal people do. That's what people who aren't faking do. They don't want to be hurt. And he didn't. And he told the jury that. He's like, I was hoping I was fine, because why? These things take time to build. And it was a month later that it was really kicking hard. And this guy's a tough guy. I mean, he was a blue collar worker, suck it up kind of guy. And that's what he did. But the insurance tried to use it against him. That's why they offered so little before trial, because they thought they were going to win the day with, he didn't go to the emergency room right away. He didn't treat every day after the wreck. He waited. So that must mean he's lying. No. And the jurors agreed with us. But sometimes the jurors don't, right? I mean, they could have easily said, yeah, I don't get it either. If I was that injured, I would have gone immediately. I would have not waited a month. Maybe something's up there. And they could have easily reduced the verdict for that reason if they thought something might be awry. So delayed onset is a big issue because it causes people to wait. And then any of that can be used against them, because people got to know this is the typical tactic used, is try to just, create smoke and say, we don't think it came from here. And they point to all these different things. And if they have both of them, it's even easier for them. Oh, we got a pre-existing injury and we've got you delaying. And they're going to argue that till they're blue in the face, that this means your injuries aren't legit in the sense that they didn't come from this wreck. And you don't want to do that.
Thank you for always having such great examples. I think people can really understand more when you share those examples of cases. So we have walked through the major injury categories and how Georgia law treats them. Now let's get into the mechanics, medical evidence, expert testimony, and how the case actually gets proven. So the first 3 days after a crash do more to shape the outcome of the case than any single decision later on, kind of like what you were just saying. What should someone do in the first 72 hours after an Atlanta car accident to protect both their injury claim and their future compensation?
So two categories of things that they need to be thinking of to protect in the first 72 hours. Number one, don't assume that liability is not going to be fought. Okay. And liability means who's at fault, right? Remember, I said earlier, most of these car wreck cases do come down to just a damages argument. We're not arguing over who's at fault. But what if you're in that small percentage? Don't just assume because it's a rear end collision, oh, it's always the guy that rear ends. We're not going to have a fault issue. So I tell people always assume fault's going to be argued. Why? Because in the first 72 hours, evidence of who's at fault could disappear. You want to take photographs. We've got other videos that go through this. You want to secure as much of the evidence yourself that you can. Witnesses, get all their information. Video goes away very quickly, especially in Atlanta. If you're on a side road or, the connector or things like that, there's businesses all over the place. They don't keep their security video very long. It might have caught the wreck. Easiest way to prove who's at fault, right? So fault is the first issue. Don't just assume. You want to secure what you can secure evidence-wise, because you haven't talked to an attorney most likely in the first few hours or day, and get that secured. The other is what we talked about earlier, which is don't just assume you're fine. And remember, a lot of these injuries are delayed onset injuries, at least to the extent that you realize it's big enough that I need to do something. I'm a little sore. I'm cool. And then you wait a week and it turns out it's a herniated disc. It's because of the delayed onset. If you can, go get checked out. Don't wait. You don't want to give the insurance company and their lawyers arguments that you didn't do certain things and the normal person would have. You didn't go by EMS. You didn't go to the emergency room. You waited a couple of weeks or a couple of days even. So you don't want to fall into that trap. All of that can affect the value of your case, because obviously if you have a liability fight, you're in a lower percentage. Most don't have to fight over it. Now you're having to fight over liability, and they get to say, hey, we can't pay you out as much because we think you're somewhat at fault or fully at fault. And you don't have the evidence to show, no, that's not true. Here's what happened. And then again, the delayed onset. Think of the guy that we just talked about. $550,000 offer is all they gave this gentleman. And clearly they were wrong. The jury said they were wrong of his own peers. by, I mean, I don't even know what that percentage is, right? 550 to 3.28 million. That's way off, right? But a lot of it was because he had that delay. He had that delay in treatment, and they just, I'm telling you, they salivate over that stuff. And again, I think they're wrong more than they're right with that. And clearly we're in this one, thank God, but don't give them that argument. And if you delay and give them that argument, look what he had to do. He had to go all the way and risk it at trial because he could not convince the insurance company that the delay is not going to kill his case. So, those are the two things that you really, that first 72 hours, man, you want to have the documentation, meaning medical records of what you're complaining of. So later on we can show, see, he was complaining of his shoulder and his neck from day one, went in. Yeah, he said it was only sore. That's okay, because you're supposed to tell the truth, right? That's fine. We can explain why you said it was only sore day one, but turned into a herniated disc instead of not going at all. That's not what you should do. So 72 hours, real important. Do those two things for yourself. And then obviously I always tell people, at least call a lawyer. Please just call them. You don't have to hire them necessarily, but get this type of advice. Make sure you're doing the right things within that first 72.
So most people outside of personal injury law have never heard this term, but it might be the single most important concept in the entire process. What is maximum medical improvement, and why is it the turning point in an Atlanta compensation case?
Great question. Maximum medical improvement means from a doctor's standpoint, and this could be physical therapy as well. So like physical therapy, and then your doctor also saying, yeah, you're, and the phrase is MMI, right? You're now MMI. You have reached maximum medical improvement. It means there is nothing more that the doctors can do for your injuries. You, in essence, have plateaued. Okay. Now, what we're hoping is that MMI is 100%, meaning your injuries are in essence cured. You're fully back to where you were before the wreck occurred. That's perfect. That's great for you personally. Now, what typically happens is MMI isn't 100%. They've gotten you as far as they can go, but there's no other surgeries or surgeries at all. There's no more physical therapy or anything, or shots or any other medical treatment that's going to get you further along. And it's so important for a case, in my opinion, because in every case, I don't want to even contemplate settling a case, if we can, until you reach MMI. Why? Because remember, what this is all about is, what are your injuries? What did it take medical wise, meaning what are your medical bills to reach MMI? And then also, what MMI are you? Do you have permanent injuries? Did they get you to 80% and you're going to be 20% disabled in essence for the rest of your life? We want to wait until that MMI occurs, because now we have the full picture of the value of your case, because all those things are so important. If we try to settle a case before MMI, we're guessing. Yeah, she's still in treatment. So think of yourself, right? A herniated disc. Yeah, she's still in treatment. She hasn't reached MMI yet. She may need a surgery. She may not. It may be 8 more weeks of physical therapy. She may have this level of pain for the rest of her life, or it may be 8 more weeks. We don't know. Well, how's an insurance company going to say, well, we can offer you this or this or this, or how can I even say what the value is? Because the value would be totally different if you ended up needing a surgery versus you're going to be better in 8 weeks. They're going to get you to 100% MMI in 8 weeks. We need to know. Otherwise, we're just guessing. And my biggest fear for that, and why it's such an important milestone in the case, is I don't want to, for my client, settle your case short. The insurance company will only settle based off of the snapshot at the time. They hate future treatment because in their eyes, they're looking at it and going, you're never going to have it. I'm not going to pay you, ma'am, for your herniated disc surgery that you say you're going to have in the future, which, by the way, is a $100,000 surgery. We're not paying you $100,000 for a future surgery because you're just going to take the $100,000 and not have the surgery. They want it in the can. So I can't bring that value for you just on a guess that you're going to have it. You got to have it in the can. So MMI is massively important to make sure that we are doing our first job, which is maximizing the recovery for you in your case. Can't do it if you haven't reached MMI yet, because we don't know how much more treatment you're going to need. We don't know how much longer you're going to have pain and suffering. We don't know what the MMI percentage is going to be. So at the end of the day, it's almost everything in a case, right? Because it controls all the value mechanisms, both in the insurance company's eyes and certainly ours. And we don't want to do anything until we get to that stage. So we'll make sure we're not missing anything.
And when liability is disputed or the crash involves multiple vehicles, the case often comes down to what the physical evidence and the video can prove. What is accident reconstruction, and how do Dashcam and surveillance footage strengthen an Atlanta injury claim?
So I'm going to take that second part first, if I could, because it'll probably explain it a little bit better. Dashcam and video those are the best evidence you can get. It shows the actual wreck. It proves liability, and only in, I would say, less than 1% chance that it wouldn't, right? The angle's bad or something like that might come up. It is the evidence, right? I mean, it's like they say, a picture's worth 1,000 words. Video's worth, 20 times that, right? Because it can prove liability in and of itself. When we don't have dash cam or video, which is very often, okay, it's very rare that we have dash cam or video. Love when we have it, but it's rare. Then if we have a liability dispute, we may have to rely on what you just asked, what an accident reconstruction. Accident reconstructionist is the person that does it. And that is, think of the police. It's the same kind of, most are ex-police officers. It is an expert with knowledge that can go out and recreate the accident by looking at, it's really fascinating, by looking at the crumple damage of the vehicles, the police report as well, the actual scene, how the road is set up. They scientifically can go back and say, this is exactly how it happened. So they're basically recreating that video that doesn't exist, right? And trying to supplant it by saying, here's how the wreck occurred. Therefore, this person's at fault. Accident reconstruction, in my practice, certainly, it's rare to go there. Again, one, just naturally because it's rare that we're going to have a liability fight. And it's very expensive. So we have to weigh the cost analysis of, do we need to go so far as having an accident reconstructionist, or can we go without it? The other is a trial strategy. I'm of the ilk, if you will, trial lawyers that believe less is more, especially in this day and age. Anytime you have to have an accident reconstruction expert to fight liability, I think you're at a disadvantage. Because just naturally, you can't just simply show who's at fault, right? With the stories of the drivers and whatever else. You have to have this expert who's a hired gun. So you're going to get that argument. Oh, of course, your expert is going to say the other person's at fault because you paid them $10,000 to say it. You're having to over-explain, and that's not a good thing. But there are times where you have no choice and you're going to have to get an accident reconstructionist. Now, they are really, really good. We have a great one here in the state of Georgia that we use. They've gotten it now where they bring a drone and they do like drone footage of the scene so they can show exactly what the roadway looked like and all of that. They come with great credentials and they can be really, really helpful in those rare cases where, the damages are high enough so it makes sense to spend 10, 20, 30 grand on an accident reconstruction expert in their testimony. And the liability fight is that hard. It's that deep ingrained of who's at fault. My best example to give people, another motorcycle wreck that I had, it was a motorcycle versus a tractor trailer of all things. And it was a side road, again, down in the Savannah area, because that tends to be where most of the motorcyclists are. Side road. The tractor trailer is coming out of a industrial area, having just dropped off a load, and is going to be making a left-hand turn across 2 lanes of traffic into the other lanes. And they have a stop sign. My guy is in the fast lane, so the left-hand lane, on his bike going straight. There is no traffic signals. He has the right of way. Tractor trailer pulls out, and my guy tries to avoid it and lays the bike down, hits it. He's got massive injuries. Well, the tractor trailer lied and told the police that my guy went on the opposite side of the road and he was all the way through his turn, and my guy hit him in the opposite lanes of travel, showing that he's at fault, meaning he was way into his turn and our guy was going to, because they always blame the motorcyclist. Oh, it must have been, going 90 miles an hour, that sort of thing. We had to, my guy was adamant, and I'm like, I don't know. This is what the police report says. We had to hire an accident reconstructionist. And guess what? The accident reconstructionist flipped the police officer. The police officer goes, yeah, I was just going off of what the truck driver said, but the accident reconstructionist was able to show there is literally no scientific way this guy was in the other lanes of travel. Here's how it actually happened. And it was, sure enough, he pulled right out in front of him and caused the wreck. We were able to resolve that case for $1 million, which was the full amount of insurance coverage. And it was, my guy was found at fault. My guy was found at fault by the police because they just went by, they weren't there. There was no video. They went by the statement. My guy was passed out, by the way. He had to be taken to the hospital, so they didn't have his testimony. And the officers there and the tractor trailer, from the way it looked, okay, yeah, that makes sense. So we had no choice in ones like that. So that's when it really makes sense to spend that money and get an accident reconstructionist.
That is a great example, and congratulations on the case doing so. Yeah. And the insurance company is going to have experts, and so the plaintiff has to have them too. What role do medical experts and expert witnesses play in proving both the cause and the value of an Atlanta injury?
In most cases, they're everything. Okay. Now, why is what people need to understand. Again, it's because the vast majority of injuries are your back and neck injuries, your spinal injuries. Again, think bulging disc, herniated disc. Those can come from anywhere. So again, you're having all those natural arguments that, hey, it didn't come from this wreck. They're going to hire an orthopedist that's going to say, no. This is a term that they love. This is degenerative disc disease. Okay. I don't know if you've ever heard that. They call it DDD, right? And it's not a real diagnosis. It's a faux diagnosis, but it's in the records all over the place all the time. And what it means is, oh, this didn't come from trauma. This came from just ordinary life and the wearing down of that disc, which truly can happen. Okay. Because over the years, it's a shock absorber, right? And so it's going to start to deteriorate. And so as you age, that deterioration's happening. And most doctors are going to say by 30 years old, you're going to have some of that degeneration, meaning it's just a chronic thing. It's not something from trauma. So because they always can have those arguments, medical testimony becomes necessary. In the state of Georgia, in those kinds of scenarios, you, as a plaintiff, you would have to have a medical doctor who can say under oath these phrases within a reasonable degree of medical certainty. Her herniated disc came from this motor vehicle wreck. That's then expert testimony from a doctor saying causation. The wreck caused the herniated disc. Now, obviously, they'll have to testify and get cross-examined. And why did you come to that opinion? And isn't it not DDD? Isn't it not degenerative disc disease, that she's always had this, versus it being herniated in the wreck? But that's why oftentimes in these cases, you got to have medical testimony. Flip of that is your burn injuries, your broken bones, internal blunt force trauma ones. You don't need a medical expert to prove causation, meaning you can try your case without it if you want to, because you don't have to have that within a reasonable degree of medical certainty. This fracture came from the wreck, because the law says any juror could just look at it and say, yeah, it did. We don't need expert testimony on it. Still reasons why you may want to have an expert. Other reasons are for the damages. If you need a doctor to explain to a jury what this means for you for the rest of your life. So to give you that example, again, I keep going back to it in this episode, that jury trial that I had with the herniated disc. I needed him, the doctor, the surgeon, not only to give me that reasonable degree of medical certainty, the cervical disc injury came from the wreck. Good, check, got that done. What I really wanted him for was the long-term permanency of the injury. So where they really help he came and testified to two very, very important things for our case. Number one, what's called permanent partial impairment, meaning what's your impairment from this injury for the rest of your life? And they can put it into a percentage. And so he put it at 20%. He is 20% in essence disabled from his neck for the rest of his life. And that's massive in explaining to a jury what I'm trying to explain to them, because I'm just the lawyer going, look at the evidence, look at all the things he's telling you he's been through and he's going to be through for the rest of his life. But now I've got a medical doctor who has no dog in the fight, not a hired gun, who's saying I can medically say, and there's a book of how they get to the calculation, he is 20% disabled for the rest of his life from that neck surgery because he's got all the stuff in there and it had to fuse the disc and all of that. But then he went one step further, and this was great. He talked about, Ted and jury, not only is he 20% disabled now for the rest of his life, but anytime you have a cervical fusion surgery like this, you're going to have deterioration of the disc above and the disc below going on for the rest of his life. And at some point, and then he quoted the percentage, he said the medical evidence is 50% of cases where you have a fusion surgery, you're going to have another fusion surgery in the future to a level above or below. And so I was able to argue for, and the jury gave, future medical costs for his 10 years in the future next cervical fusion surgery. But I couldn't have done it without the testimony of the expert, which is the medical doctor. So long way to explain, this is why you need a trial lawyer to make some of these decisions when you have to have an expert, and it's going to be most of these neck and back cases, and when you don't need one. And again, even if you don't need it, do you still want one, and how that all plays together?
Yeah, thank you. And I love how you explain all of this with so much passion, and I can tell that you really truly care about your clients, which is incredible. So we have covered the injuries, the medical evidence, and the experts who prove the case. Now let's get into the compensation side, how insurance companies calculate offers, how Georgia's damages model works, and the specific Georgia rules that trip up cases if they are not handled right. I know we've talked about some of this a little bit here and there, but for this last section, we're going to get into the compensation side. So most people think a car accident case is just the medical bills, and it is a lot more than that. What types of damages can someone recover after a serious Atlanta car accident injury beyond just medical bills?
So three main categories, and everyone knows these three main, but there is nuance to it that I think people miss, and it's really important. First is your medical costs. But what's important there that people miss is it's past, present, and potentially future. You may have one or all three. May still be treating, so you have past and present. May still be treating, and you're going to be treating for another couple of years or the rest of your life. Think of the example we just gave where 10 years from now, he's going to have another surgery. So he had past, present, and future medical costs. Each one of those separate item or line item that then total your medical costs. So that's bucket number one, in essence, for your damages is medical costs, medical bills. Then next, similar, would be lost wages. Some people have none, so you don't have that category at all. And then others do have it. Then it becomes, again, the nuance being it could be past, present, and future lost wages. You have already incurred, you're continuing to incur, and you may continue to incur for years or the rest of your life. Again, separate line items that then total up your lost wage claim. That's bucket two. And then bucket three, everybody has, and that's pain and suffering. Again, the nuance, though, is it's potentially past, present, and future. Everyone wants to talk, and certainly insurance companies only want to talk about past, right? So what was their pain and suffering up to the day? And all right, this is what we think it's worth. No, what is the ongoing and what's the potential future? Another year, brain needs another year to heal. So another year of pain and suffering. My guy that we were just talking about with the trial, pain and suffering, 20% permanent impairment for the rest of his life. So past, present, future for each of these items becomes very important. Again, separate line items, then total up for your pain and suffering. So then you go medical bills, lost wages if you have it, pain and suffering, combine them all up, That's the damages you're pursuing in 99.9% of the cases. Every once in a while, you have a fourth category. And I think we talked about this in episode 2 a little bit as well. Punitive damages. That is a totally separate category. It's not to compensate you for things that you've been through, bills, lost wages, or pain and suffering. It is to punish civilly someone for doing something severe to cause your injury. Best example is, think of DUI. Drinking and driving, drugs, driving. That is a criminal offense beyond just a traffic ticket. You can pursue punitive damages against the defendant. Yes, it gives you that compensation, but it's ultimately to try to punish civilly that person for doing something egregious like getting behind the wheel when you're intoxicated. Rare that you have it. Again, there's some other examples of when punitives could come in, but you need to see if you've got it, because it can definitely change the value of your case.
And so let's say the offer shows up and it feels like a slap in the face, and there is a specific methodology behind it. How does the insurance company actually calculate a settlement offer in Georgia, and why is the first offer almost always a lowball?
That second question is a great one, because everyone trips up on that. So first, let me talk about how they typically calculate it. They are beholden, and wrongfully so, but they are for a reason, to the statistical numbers. What do I mean by that? What are your hard damages that you can prove? What are your medical bills, potentially lost wages? They absolutely hate lost wages. If you can really prove the lost wages, they'll add it in there. And then typically what they do is they go, okay, we'll pay you that plus something on top. And typically they're doing it by percentages. So they're going, okay, it'll be, and typically in a pre-suit, they love the, at most 2 times your special damages being the combination of bills and lost wages. So you got $5,000 in bills and lost wages. Ultimately we'll settle for $10,000. That's the value of your case, because it's empirical. They want to keep it as empirical and as little emotion as possible. So what they undervalue is the pain and suffering side. So that's where we really dig in and fight, because again, they just look at, because think of like your brain injury case. They misvalue those all the time. Why? Because it doesn't fit into their model. Again, brain injury cases, it's low treatment. So you're going to have low medical bills. But in my opinion, it's high pain and suffering. There's not much medically they can do for you. You got to let the brain heal. But it also means you're having to suffer through all of that, because there is no quick fix. Your broken bone cases can be smaller because there's a quick fix. Your bills are going to be higher, but your pain and suffering is way lower because they can fix it quickly, right? But they love the broken bone one because they got something empirical. $10,000 to fix that bone. Okay. $20,000 case. There you go. Brain injury. You might have 3,000 in bills, but you got 9 months of massive pain and suffering with all the symptoms you're going through. And they're going to say that's $6,000 case. 3 times 2, 6, right? So we're fighting this system, and there's a lot of stuff people can see out there. And yes, it is true. They use computers. They use computer models. They plug in these statistics and it shoots out a number. It literally becomes that in a lot of these situations. And the computer tells them what the case is worth. And that's the max of their authority. Put in the medical bills and lost wages, if they even agree to include them, spits out a number. It's a $12,000 case. And that's the highest they go. But they're always going to offer something low. Even if the computer spits out something, 12 grand, right? They're not going to offer you 12 grand. They're going to offer you 4, right? Why do they do it? Was that question you asked that everyone struggles with. Well, God, why, Ted, are they coming with such a low offer? Well, because it's a negotiation, number one, right? And I can't tell you how many times it becomes financial warfare. And what do I mean by that? Well, we're going to lowball it because she might get annoyed by the process. And at some point, she also might become desperate. She has lost wages. She's missed time from work. She needs income. And how do we not know at some point, even though Ted knows the value is way higher, that she's not going to come back and go, you know what? I'm just sick of this and I'm done. And this is, I don't have time for this. Just take the offer. Just take the $4 grand, or $5 grand or whatever. And unfortunately, I've had that happen. Not a lot, but it does. I've had several cases where I've told them it's worth way more, but because of personal circumstances, they take the low ball offer because they have no choice at that time against my advice. If that's happening with a lawyer, how many times is that happening without a lawyer, right? And so they've got the benefit of, we don't have to, legally, we don't have to pay you anything. The only legal right you have, and this is what I always tell my clients, the only legal right you have is to try your case to 12 jurors of your peers and have them tell you what it's worth. Then you can force the insurance company to pay what that number is. Before that, it takes two to tango, and the insurance does not have to settle. Neither do you, but they don't have to. So sometimes they just play the long game because they have so many of these cases. And the other thing that frustrates people, and I tell them, 99% of the time, what they offer you has nothing to do with your case. And that blows people's minds. They're like, what do you mean? That's the whole point. Well, yeah, technically it is the whole point, but this is a business. They have tens of thousands at any given day of these types of cases. And they're looking at their business, their global business. So it becomes more than just you. It's where are they? Where is it in the year? Where are they locally with how many they've settled and haven't? You know, what's the arguments in your specific case, but what's our global payouts right now? And they might say, hey, why are we going to pay her $500,000 now when we can hold on to $500,000 for a couple of years? Because it's going to take a couple of years nowadays to get to trial because that's her only legal right. And we're making interest on that $500,000. Yeah, we'll eventually have to pay it out, but why do it early, right? I mean, you just don't know what's going in. And so I tell people, you just have to focus on one, you're in it for the long haul if that's what it requires. Hopefully it doesn't. And you focus, unlike the insurance company, you focus only on your case. What's the true potential value of my case and what are my personal circumstances and what am I willing to do and not willing to do and go from there. That's how you ensure you get just compensation.
Wow. Yeah, there are so many factors that go into it. And then I know we've talked about this one a little bit, but when someone cannot work after a crash, the financial pressure is brutal and the damages math gets large fast. So how are lost wages, future earning capacity, and permanent disabilities calculated in Georgia injury case?
So again, those are a separate bucket item of damage. Lost wages are the easiest of all of them to prove. Okay. Traditional lost wages are, it's time that you've missed from work in essence. And the easiest, of course, is when you're a W-2 employee, right? Because you probably have PTO, those sorts of things. And by the way, even if you use PTO, it's compensable because you would have been using PTO for vacation or sicknesses, not this wreck. So you still get the value of your time missed, even if you're using PTO. W-2 employee is easier, right? Because you know what your wage is, how much time you missed. That's an easy calculation. Okay. And again, remember it's past, present, and future. Do you have future going to happen? Is it going on right now, or is this all in the past? The harder is lost earnings, because lost earnings means you're not W-2, you're self-employed, right? So entrepreneur, maybe it's your own business, maybe you're just an independent contractor, you know, it kind of depends, but now you're kind of talking more lost profits, right? That becomes harder because now what you got to do is show what was your average, what were you making typically in a given month, year, 2 years, whatever, and say, I would have done that for this time period. You know, so like an easy example is I missed 3 months of running my business because of my injuries. Okay. And if you're the only person, sole entrepreneur, you have zero income coming in. All right. Well, what did you do for the 3 months before? Okay. Then look even further. What's the average month for the past 6 months or year? And then you average it and say, okay, well, you know, I was making $5,000 a month profit running my business. I missed 3 months. There's your calculation. Got to back it up though with documents. You can't just say these things. You're going to have to show it. Tax returns, receipts, sales, whatever it ends up being. So it becomes a more difficult thing. And then you've got what's called lost earning capacity, which is more of your future. Okay. So that it could be lost wages, a W-2 situation, or it can be entrepreneur. Easier again, W-2 than it would be otherwise. But lost earning capacity is, well, now I have permanent injuries. I used to work 40 hours a week. Now, because of the doctors and my injuries, I can only work 20. Okay. So that means a loss of X. into the future, lost earning capacity. I could have earned 40 hours a week. I'm now going to earn in the future 20 hours. So it's lost earning capacity. And again, obviously it changes value of your entire case because it's a bucket item of your damages that you can easily prove with documentation and testimony. And it increases the value of your case because it's another loss that you have that you're asking the jury ultimately to pay you for.
And these cases play by different rules and often produce significantly larger claims. What specific rules apply when a commercial truck, let's say on I-775, or a rideshare driver is involved in an Atlanta crash?
Yeah. So first, the commercial vehicle truck case. It's funny you say I-75. I've got a case right now dealing with I-75 with a truck. Good example. There are, with tractor trailers, there are federal regulations that Georgia also adopts that highly regulate everything regarding a trucking company and the truck driver. So in this example, there is a federal regulation that truckers have to keep their vehicle in a certain number of lanes and can't go over into like your second to fast lane or fast lane in certain scenarios, depending on how many lanes and where you are. Well, this guy violated that regulation at the time of the wreck, and it was a rear end collision. He was in the wrong lane. He was in a lane he was not supposed to be in. It's just an easy way of proving the negligence because it's showing a clear rule violation, right? So not only was he following too closely, naturally, and rear-ending my client, but he never should have been in that lane to begin with. He was supposed to be, for this reason, 2 lanes over into a slower lane because he's driving this guy driving a gas truck. So of all things, he had a bunch of petroleum in the back of his thing. I mean, you're talking like a bomb going down the road type thing. So it could have been way worse. So that's where it gets unique with the law in trucking cases, as we call them, these commercial vehicle truck cases. That's more law-based, meaning liability and those sorts of things. Flip to your rideshare, Uber, Lyft type cases. It's a different thing to be looking at, but it's not legal in the sense of liability type issues. It's more insurance-based. So the difference with rideshare is you have different insurance levels potentially kicking in depending on the rideshare driver, if they're at fault versus not at fault, and what they were doing when. As strange as it is, and I think we talk about this in another episode, the layers reduce down depending on what the driver was doing if the rideshare driver's at fault. If they were actually transporting a passenger or going to pick up a passenger, it's the highest level. If they were on the way to pick up a passenger when they hit you, it's a little bit lower. And then if they were just waiting on a ride on their app, but they hadn't actually accepted it yet, it's then the lowest level. So strangely, it affects what insurance is available in your rideshare versus it being something substantive with your actual case itself.
And then this is the recovery path nobody thinks about until the worst has already happened. What happens when the at-fault driver is uninsured, underinsured, or fled the scene? And I know we've talked about that a little bit. So if you want to do a quick recap of that. And then part 2 of the question, how does Georgia handle wrongful death?
So with the scenario of uninsured, underinsured, or hit and run, this is where your insurance comes into play. And it's vital. It's your auto insurance, and it's called short for uninsured or underinsured motorist. It is insurance that you purchase on your policy to protect you in these scenarios when the driver's known and has no insurance, uninsured. Driver cannot be found, hit and run, considered uninsured. Or the more typical case, which is they have insurance, but they only had minimum coverage, for example, or even above minimum, but your case is worth a lot more. That's underinsured. Your insurance steps in if you have it, and in Georgia, you're not required to have it. A lot of people don't have it to protect you. And so you actually go after your insurance policy to recover compensation. And it's vital in the hit and run and the uninsured, because otherwise you have no avenue to recover. But it's also dangerous and needed when it's the underinsured situation, because there is coverage. You're going to get a recovery, but it's too small. So you really needed more coverage. Well, that's where it could come in. But if you don't have it, then you're stuck with whatever the at-fault party had. And this is where I call this being Russian roulette, because you don't know who's going to hit you and whether they have coverage or if they have enough. And you could be massively injured. So is massively important. I get on my soapbox all the time with folks. You got to get as much as possible. If you get nothing else from this episode, please check your coverage and maximize it. It is cheap, and it is the only insurance that's there to actually protect you and your family when you're injured. So that's that scenario. Now, on wrongful death, it's very nuanced. And the reason for that is a couple of things. Wrongful death, there can be two cases by two different claimants. Wrongful death is one claim, okay? And that is for the death of the person. And what it means in Georgia is the value of the life that was lost, but the value of the life to that person, meaning you took their life away. They would have had all this additional enjoyment of life and everything else, careers, family. What is that worth? That's wrongful death. But also in wrongful death, there's typically two things. One, medical costs oftentimes come into play. They didn't pass away right away, went to the hospital. There's a hospital bill, God forbid, really horrible ones. Days or weeks or months later, they pass away. And there's medical costs. Two, there might be pain and suffering. They survived the scene. They were suffering from the injuries and then passed away. Those claims are actually the party that has it is the estate, not the family. The family has the wrongful death claim. So this is real important, and why in wrongful death cases, I always tell people, always you're going to need an attorney, because for no other reason, there's some interesting legal maneuvers made between those two cases that can help protect any sort of settlement or verdict that you get. And I won't go into all of that because it's really detail oriented, but it's sectioning off those two different claims, knowing who has the rights to what. So family, and there's a statute, there's a wrongful death statute, by the way, that tells you the hierarchy of who has the claim depending on who survived the deceased person versus your estate claim. And estate claims only limited to your medical and your pain and suffering. So real important in wrongful death cases, talk to a lawyer, even more so than any of these other types of cases.
All right. And then we're getting into one of the last questions here. There are rules that quietly destroy cases that should have been strong. How does Georgia's 50% comparative fault rule, the 2-year statute of limitations, and anti-litem notice affect what someone recovers, and when should someone hire an attorney?
So I'll do the easy one first. Statute of limitations. That is what it says. It's your limitation. It's the deadline within which you have to file a lawsuit, not claim. Claim is just calling an adjuster and setting up a claim. This is lawsuit in court against the at-fault party, or you forever lose your rights. Typical statute in Georgia is 2 years for personal injury. There are exceptions to that. There are different statute of limitations for unique cases, but we're talking car wrecks here. That's always 2 years. There might be ways to extend it, but think 2 years, got to have a lawsuit filed, or you forever lose your rights. Insurance doesn't have to pay you anything. They'll stop talking to you. You're done. The other one was anti-litem notice. That's when you're going against a government. So think state, county, or city. Different, in essence, statute of limitation, but it's really not. So I'm going to get a little nuanced here. There's an initial requirement called the anti-litem notice that if you blow that and you don't do it, you then lose your right to continue your claim, even though the statute of limitation hasn't run yet. So think of your car wreck. Gave an example earlier of the police officer in a motorcycle case. Had to do that was a city police officer. So city, you have to do an anti-litem notice to the city within 6 months of the wreck. He still has a 2-year statute of limitations to file an actual lawsuit against the city, but he can't even get there unless he's done his 6-month anti-litem notice. And the anti-litem notice has specific legal requirements, and no one should do an anti-litem notice on their own because if you mess that up, it's statutory. You didn't send it the right way. You didn't put the right information in it. you're done. You don't do the anti-litem notice, don't do it right, case over. County is 1 year, state is 1 year anti-litem notice. So different time frames. You got to know which one. And so anytime you're dealing with the government, talk to a lawyer, much less you're going to need to hire a lawyer. It's kind of like wrongful death. Always would need a lawyer in those scenarios. So another big one doesn't come up as often. So again, remember, good news for listeners. Oftentimes, car wreck, you're not going to have a liability fight, but this is where you do have a liability fight. Now, naturally, the other side's hoping the liability fight is, hey, you are actually 100% at fault. That is easy because it means you get zero, right? And that's what they're hoping for. But what more naturally comes up in liability fights is you may be somewhat at fault, like you didn't do something, you didn't have a blinker on, or you didn't have your headlights on, or, you could have done X to avoid it. Now you're not 100% at fault, neither is the defendant. Well, in Georgia, we have what's called a comparative negligence law. We're a comparative negligence state. What does that mean? It's not all or nothing, but you have to hit a certain percentage to even be able to recover anything. So where is that line in the sand? It's at 50%. So if ultimately the jury, who's the determiner, says that both of you are 50% at fault for the wreck, plaintiff gets zero. Okay, so 50% or more at fault, plaintiff, you get zero. Obviously, all the way up to 100%. Anything below 50% that is put on to the plaintiff, it reduces your recovery by that percentage. So 40%. All right, we the jury believe that the defendant is 60% at fault and the plaintiff is 40% at fault. Now, as a plaintiff, you get a recovery, but the verdict is reduced by 40%. So jury comes back, gives that percentage, and then says $100,000 is the value of your case. Now the judge reduces that verdict from $100,000 down to $40,000 because the responsibility reduces your amount. So it's a percentage game there, but again, you're worried about that first red line in the sand of 50%. We have got to be able, as your attorneys, to find that the defendant is at least 51, because now you can recover something. If we can't do that, then you're at zero. And so a good example, and we get these often, is these intersection wrecks. And it's an argument over who had the red light, who had the green light. No video that proves it. We've got one right now. It's a turn. So our guy's going straight. Defendant is going to be turning left in front of them. Was there a green arrow, or was it just you got to wait and yield and then you can turn? Turns out it was a no arrow. You got to wait and yield. Well, now we're fighting over, did she yield? Did she not yield? That sort of thing. Other cases we're fighting over who had, one's coming from one direction, one's coming from the other. Who had the green light? Who had the red light? Both are saying they have it. I had a classic case, I think we talked about last episode, with MARTA, where it was one of those scenarios. And the MARTA driver lied and said she had the green light. And she slammed into my guy who was making a left out of a side road in downtown Atlanta. He had the green light. Well, we got the video from MARTA on the bus, and it proved right there it is. Got her face like mine right now, and right above her, there's the light. And it literally shows red, and she blows right through it. Lied. Cop gives both tickets because he can't prove one or the other. And so, you get those scenarios, but when you don't have that proof, then it becomes a he said, she said. And the theory is, well, the jury's going to go, I don't know who's at fault. You say you had it, they had it. We don't know who had it. So we're just going to say 50-50. We don't know. One of y'all had it, one of y'all didn't. But 50-50 then means zero to our client. It doesn't mean they get 50% of their recovery. So it's a real nasty situation in that scenario where you're sitting there going, I wasn't at fault, but yet I'm not getting a recovery. So it's definitely something for people to know because it can affect ultimately your recovery.
Yeah, that sounds like it can get really complicated, but you make it very easy to understand. So Ted, this has been incredibly valuable. We covered everything from the crash types we see every day and to the injuries that follow, to how Georgia law actually determines what a case is worth. For someone watching this who has just been in a car accident here in Atlanta and is dealing with injuries right now, what is the one thing you want them to remember?
I think the one thing I want them to remember is our conversation about the delayed onset of injury and how 99.9% of these cases are neck and back type injuries that fall into that delay, okay, where if you wait to get treatment and those sorts of things, you're putting yourself behind the 8 ball and you're literally gifting the insurance company and their attorney arguments that they otherwise wouldn't have. So don't wait to get treatment. Again, it's not about making things up. You don't want to, lie and say, yeah, I'm hurt when I'm not. But when you're feeling the, soreness and a little bit of pain here or there, that's the go get checked out immediately type thing, even though you may think it's not going to be a big deal because you don't know what's going to happen in the days or weeks later because of that delayed onset. It could be worse. We're hoping it's not. But that way you have the documentation right there for the day of the wreck of what you were complaining about. Don't wait. Don't be the guy that says, oh, I'm going to tough it out. Not a big deal. Because again, you don't know where you're going to end up. Remember my guy who we had to try that case who did just that. It seems reasonable. Yes, it is reasonable, but it can always be used against you and you don't want to do that.
If someone wants to talk to you about their car accident and their injuries, what is the best way to reach Spaulding Injury Law? So
a couple of ways. Number one, we love talking to people. It's what we really want. So you can always just call us, and that's 470-695-9950. You can ultimately talk to me or one of the other attorneys in the office, actually get an attorney that you can talk to. Another way is you can go to our website. We have forms on there that send directly to us, and then we can get your contact information. We can reach out to you right there on our website. That's spaldinginjurylaw.com. Last way would be email. You can even email me. My email's tspaulding@spaldingfirm.com. We would love to hear from anyone. No question is too small of a question. We're here to help.
All right. You can find Spaulding Injury Law at www.spaldinginjurylaw.com or give them a call directly for a free consultation. Thank you for watching, and we will see you on the next episode of Spaulding Injury Law Podcast.